Hi guys, welcome back to Battle with Ola. Soyez le bienvenue. I am so thrilled to be here once again. Warning, this is going to be a very long video and I'll tell you why. But before I do that, public service announcement. Announcement number one. I want to make a shout out to my two editors within and without Nigeria, people who have doubled as editor and video directors for me over the 2 years and a few months that I've been here. I want to say thank you for all your correction, your support, your observations. Those are the people that contribute to the post-production, watch literally every video. Those who tell me, oh, sit still, or stop dancing around, or don't say this, or don't say that, why are you looking this way, why are you looking that way, what equipment did you use today, or why is this video like this, what's happening with the image stabilization, and what. Thank you so much. And I also want to thank my data plug that has kept me on steady data supply all this while. Thank you so much. Y'all three, yourselves, and I'm so grateful that I have you in my corner and that Battle with Ola as your support. Thank you so much. That's number one. Number two is that I keep forgetting to say this, but a number of people keep asking for my phone number or they leave me their own phone number in the comment section. The thing is, YouTube hides these comments. Any comments that contain your phone number for me to call you or that asks for my phone number is automatically hidden by YouTube in the spam folder. If I don't go to the spam folder, and I hardly ever go to the spam folder, I don't even see these comments. So please, I've asked for this again and again. I'm asking again. Stop asking for my phone number and stop dropping your phone numbers for me. Please, just contact me at houseoflivingstones@gmail.com. It's the surest. People who have contacted me, they will tell you that I would answer as soon as I can. And that's a steady way of, keeping tab on our communication, It's better that way. Please, let's do that. That's two. And the third thing is that please, before you ask a question on the channel, try and look through the channel to see if there's a video that has already or has the potential of having answered your question. It's not good for us to keep rehashing the same things or reinventing the wheel. And if you're asking for a video and it's something that we have done, we will point you in that direction, or we would expect that you would find it on your own. So please, I still have less than 200 videos, at this point. So I don't think it's something that will take you even more than 5 or 10 minutes to look through to see if there's a video that has answered your question. Very important. And if you decide to, still ask a question on the video that's been made, we would, redirect you right back to that video. The other thing that I want to say today is, I am not your lawyer until I am your lawyer. I've said this before in past videos, and it seems as if some people are not taking this serious. Please, when you ask a question, if it's a generic question that will benefit other people, if the answer to the question, making a video on it will benefit other people and not just you, that's when I get to make a video, okay? But if you're asking a question which answer needs to be tailored to you, I'd advise you to just pay for my services. I'm an actual lawyer. I have real clients off YouTube, and I have real clients from YouTube as well, people who have paid for my services. I offer document review services for graduate application for law programs, and I also offer legal consultation, advisory, and representation. So you need to sign up for a paid service if you want a tailored advisory or representation. Even in cases where I could not offer or provide what people have asked for on this channel, and they will bear me witness if they are watching this video, I have often referred them to my colleagues whom I'm certain of as competent enough to provide them this service, and I don't even interfere with the payment, negotiation and what have you. So please, I often leave this information in the description box, and I keep saying it that, oh, I'll leave this in the description box, I'll leave that in the description box. But apparently some of you don't even check the description box. That's a big loss for you. So from today, make up your mind. Say to yourself, I will check the description box. Start with this video, and then you will see all the myriads of opportunities and gateways to enjoying the different services provided by Batok with Ola or by Mujola Lua of Batok with Ola. So please, these are things that I wanted to say. If you require the services of a lawyer, you have to pay for it. It's not free. and you will get the services of a lawyer as is appropriate to your situation, whether it's consultation you need, advisory or representation, or whether it's document review for graduate application to law programs. I'm so grateful to everyone that has signed up for this service. I have got absolutely amazing feedback from some of you. Sometimes I don't even know where you have found me from, and then at some point, I recently asked someone, I said, how did you find me? And then she was telling me that, oh, I watched your video on how you shared your Queen Mary University LLM application document, and then I decided to watch all your videos, and then I decided to contact you. So thank you so much. Thank you for the absolutely amazing feedback. It's been great working with all of you that have paid for my services as a document reviewer or as a lawyer off bat with Ola, and that I've paid for my colleagues' services whom I've referred you to or referred to you as well. So today we want to talk about a topic that I've been asked questions on a number of times. I think I have had people ask for this about 3 times. This topic has been living rent-free in my head for so long, and I've been meaning to actually do a video on it. But today is the day that the Lord has made for us to talk about enforcement of judgments. Also, before I move on, YouTube, I was looking at the statistics and I realized that a good number of people do not even watch the videos till the end. I don't know why you wouldn't do that. And I don't know why you'd do that to yourself, actually. But we will continue to channel good content, and I hope that those who actually need it will continue to find the value that they need. So let's talk about enforcement of judgment in Nigeria today. What's enforcement of judgment? Enforcement is the means by which we give life, we give substance, we give meaning, and we give expression to the decisions of our courts in Nigeria and actually all over the world. So after a judgment has been pronounced, it needs to be executed. That is what the law has said, what the court has said needs to be carried out. And the way by which that is done is by enforcement. The court does nothing in vain. I always say that. The court does nothing in vain. The law does nothing in vain. And therefore, when a court makes a pronouncement, gives an order, makes a judgment, or delivers a ruling or a judgment, it must be carried out. So we want to talk about how that is done in Nigeria. There are 2 laws that guide enforcement of judgment in Nigeria, and they are the Sheriffs and Civil Processes Act and the Judgment Enforcement Rules. And at this stage, that at the trial stage, we have the claimant and the defendants, we have the prosecutor or the prosecution and the defendant. We could also have the plaintiff and the defendant. We could also have the petitioner and the respondent for divorce matters or for some other peculiar matters. We could have the election petitioner and the respondent in election petitions. I've done videos on all of these. Please watch them. But when it comes to judgment enforcement stage, we have the judgment creditor and the judgment debtor. The judgment creditor is the person that the court has held in favor of that now needs to get the judgment debtor to do what the court has commanded them to do. So judgment creditor, judgment debtor, just like in loans and debts, there's a creditor, there's a debtor. A debtor is the person that is owing an act to be done or some money is to be paid to the creditor. A debtor is a person that is owing some monies to be paid to, an act to be done to or for the creditor. So we have judgment creditor and we have judgment debtor. Now, when does the judgment take effect? A judgment takes effect as soon as it is pronounced. As soon as it is pronounced. For instance, if the court sentences someone to jail, that the person is, or maybe to life imprisonment or death, the person is then transferred, handcuffed. As soon as the judgment is pronounced and the court rises, the person is handcuffed and transferred to the Black Maria and then taken to the prison, to be registered, to be maybe shaved, given new clothes and all of that, and then their sentence will start. So the judgment takes effect as soon as it is pronounced. But we are going to focus more on civil judgments today, civil judgments and how they are enforced. But in some cases, the court can make an extra pronouncement as to when the judgment will take effect. But the blanket rule is that a judgment takes effect as soon as it is pronounced. So if the court could say, for instance, that you're owing 1 million naira, I need you to pay it within 30 days. So which means that within those 30 days, you are free as the debtor to pay that money. Or maybe it's eviction, the court could say that move out of the property within 3 months of the pronouncement of this judgment. So you have those 3 months to actually move out, or the court will come and move you out. Okay, so that's usually what people look at as enforcement, when someone fails to do what the court has asked them to do, and then the court has to now execute by force of law, of course. That's what most people focus on. But enforcement begins as soon as the court has made a pronouncement. You are supposed to, as a judgment debtor, to immediately begin to fulfill the judgment for the creditor. Of course, this judgment settlement would probably talk about that in a much later video, but we're not talking about that. Judgment settlement just means that, for instance, if the court has awarded maybe 50 million, you can then begin to negotiate with the creditor that, okay, I don't have to, about 25 million, and then you that, okay, pay 40 million, okay, let me pay you 35, and then you settle, and then you pay that. But that's not what we're talking about today. We're talking about enforcement of what the court has actually said. So there are some exceptions anyways. For money judgments, 3 days after the court For money judgments, 3 days after the court has made a pronouncement, it takes effect, except the court has stipulated otherwise. 3 days after the pronouncement, money judgments are to be enforced. They take effect. For possession, 14 days after the pronouncement. They take effect 14 days after the pronouncement, except the court has mandated otherwise. And where any day is not specified by the court, the judgment takes it by leave of court. Now, when can a judgment be executed or enforced? Let's talk about the time and the day. A judgment can be enforced in Nigeria at any time of day between 6 a.m. and 6 p.m. That means that there's a judgment curfew, so to speak. So you cannot enforce or execute a judgment outside that time frame. So 6 a.m. and 6 p.m. And I believe that the rationale behind this is for, everything to be done in the light, in the clear, in the open, so that nobody will claim that anything was done, in the dark, or done with a sinister motive, or done contrary to law. So 6 a.m. to 6 p.m. And then judgments are to be executed on court days, that is Mondays to Fridays, so excluding public holidays. And as per days, a judgment can be executed between Monday and Saturday, court days plus Saturdays, because, courts don't really sit on Saturdays, but excluding Sundays and public holidays. So judgments cannot be executed on Sundays, cannot be executed on public holidays. But I suppose that, some of those rules and principles need to be revised, because now it's a digital world. What if you want to make a transfer, if it's a money judgment and you want to make a transfer on a Sunday or on a public holiday, or you want to make a transfer maybe by 12 a.m., if you have a daily limit and you have transferred during the day, and you want to transfer as soon as your limit is renewed, for instance, you want to transfer another money, by 12 a.m. or by 1 a.m., who's to stop you? So those are considerations for civilization and, digitalization. But that's the general rule, Mondays to Saturdays, excluding public holidays, excluding Sundays, and 6 a.m. to 6 p.m. That's when judgments are to be executed. What's the lifespan of a process of execution? An execution process, has a lifespan of 1 year from the date of issue. So if the court issued, a process, of execution, it will last 1 year the date of issue, after which you have to renew it. You have to renew it as the judgment creditor. You have to renew it. How do you get this process? You apply to courts, and usually you have to apply to courts for this process within 2 years of the judgment. So within 2 years of the pronouncement of the judgment, if need be, you should apply to court for the execution process, and then that is a writ of execution is renewable, after 1 year, because it expires after 1 year. Now, there's an important thing. If you're a judgment creditor and the judgment is not fulfilled in reasonable time, do not go to sleep, because equity aids the vigilant and not the indolent. If you say that the court has given judgment and you take no active steps when you see that the other party is unreasonable or not ready to fulfill the court judgment, you may lose out, by the passage of time, you may lose out. So it's important. I heard about a case where, there was a judgment, and, the judgment creditors for several years did not exercise, or that's if they were even original or real judgment creditors, they did not exercise what they said was, the judgment. And it was on a piece of land, a large expanse of land, and then people had built on the land. Third-party purchasers had bought the land, built on it, and all of that. In fact, the High Court of that state had already been constructed on that same land. Can you imagine? And then they now woke up someday, went rushed to court, got a writ of execution. I don't know how the judge issued it without being certain of the time frame or time lapse between the time the judgment was given and when they were now waking up to execute. And then, it caused, a really big messy kerfuffle. I don't know how they have resolved it, but I hope that they were able to resolve it well. So that's what can happen. The court will do nothing in vain, but you have to take active steps too. If the other party is not willing to comply, with the court judgment, you have to take out a writ of execution and, execute the judgment, And we'll talk about how to do that, as we go on. So if 2 years have passed, does that mean that you can no longer execute the judgment? No, it just means that you need to get leave of court. And when you're applying for leave of court to now apply for a writ of execution, you would have to explain to the court why you went to after the judgment and waited for 2 years to pass before realizing that you needed to actually take out a writ of execution to enforce the judgment. So what it means, it doesn't mean that you have lost out. So it doesn't mean that you have lost out. But in the instance that I cited, there are other variables that have come into it that will now make an outright execution very unreasonable. Because will they tell the court to move its premises out of that place? So most likely they would have to settle and, a longer process. And that's what happens when you do not execute your judgment on time. Very important. But if it's a judgment against an institution or a corporate body, you have 6 years. Against persons, you have 2 years. But against an institution or a corporate body, you have 6 within which to take of execution. You have 6 years within which to take out a writ of execution without leave of court. So there's an extended period before you then apply for leave of court to take out the writ of execution. Now, there are different modes of enforcing judgments in Nigeria. There are different modes. There's money judgment, there's judgment against persons, judgment against property, judgment against many things and so many people. The rest, that is the subject dispute, will determine what type of execution you can take out, in each instance. But now let's look at them one after the other. So how do you enforce money judgments? We have 3 broad means of enforcing money judgment. There's writ of fee, there's writ of execution, and then there's garnishee proceedings. I'm going to try and do separate videos on some of these means of enforcement much later, but today we're just going to mention them in brief. Sometimes I was talking to a friend and I was telling them that sometimes the videos are like 1 hour long, and then by the time I render and post-produce and all of that, they come back to 50 minutes or 30 minutes or 15 minutes, And the person was very surprised, and that's it. And so I don't want this video to be too long, to contain your attention span, but I'm imploring you to watch till the end so that you get all the juice. But today we're just going to be mentioning some of these things in brief. So writ of fee. Writ of fee is what you use to attach, movable property to settle money judgments. So if somebody, court has given a judgment against someone to the tune of, so if the court has given judgment against the defendant or the claimant, for instance, to the tune of maybe say 5 million naira, and they are unwilling to pay that money, or the time has lapsed for them to pay reasonably and they're not paying, and you can sense that they have movable properties that can settle this debt, but they are refusing to pay. What you need to do is to apply to the court for a writ of fee. The court will give you an order attaching their movables. So you can then take custody of their movable properties, which value, is sufficient to settle the judgment debt. The court officials, of course, not you personally. And then those properties will be auctioned off, and then the court will now pay you the judgment sum out of it. So that's writ of fee. Then writ of execution is to attach immovable property. So if the person has lands or houses and what have you, immovables, that can sufficiently settle the money judgment debt that they owe you as the judgment creditor, you apply to court telling the court that, oh, this person has land here, they have land there, we have proof that they do, so give us an order attaching those immovables. So the court will attach those immovables, and then those immovables will be sold, and the proceeds will be used to settle the judgment debt. Now, garnishee proceedings. Garnishee proceedings is how you attach someone's the monies in someone's bank accounts. So if the person has you, if you know all the bank accounts the person owes, and you know that they have monies in these bank accounts, you take out garnishee proceedings against the person, so that the court can attach monies in these accounts and command their bankers to come and show cause, to come and tell court how much this have in their account, so that the money can be straight to the judgment debt. So those three ways by which judgments are executed in Nigeria. You ask or apply for a writ of money judgments in Nigeria. Take out a writ of fee, take out a writ of execution, or take out garnishee proceedings, where the court will ask the banker of the judgment debtor to come and show cause, tell us how much is in these people's accounts. And after they have done that, we will now attach those monies and we will use it to settle the debt that they are owing in judgment. Of course, the court will not take more than what the judgment debtor, or the judgment more than what the judgment debtor owes, or more than what the judgment creditor, or more than what the judgment creditor deserves. So that is it. Now, how are these movables and immovables sold? That's for writ of fee and writ of execution. For movables, they are sold after 5 days and with the consent of the owner, that is the judgment debtor. And for immovables, they are sold after 15 days. They are sold after 15 days and with the consent of the judgment debtor. And that's because, ownership is very crucial. So, for instance, if it's a car now that the court is attaching, you can't sell it without the consent of the owner, What if the person that buys it is going on the street and someone blocks them and says, that's my car? And of course, they have to submit the ownership documents as well. So, and then they have to do change of ownership and what have you. So it's important for the owner, the judgment debtor, to be carried along and to give their consent before these movables or immovables can be sold at a court auction, in settlement of the judgment debt. And if they are perishables, they can be sold before any of these days, so that the purpose for which they are being sold will not be defeated. Now, how is the proceeds shared? The proceeds of the auction, they are distributed or applied in the following manner. The auctioneer's fee is paid, and all the expenses, incurred for the execution by the court is settled first, and then the judgment debt is paid to the creditor, and then whatever is left is returned to the judgment debtor. So if a landed property was sold for, say, 11 million naira, the auctioneer's fee will be taken out, the execution expenses will be taken out, and then if the judgment debt is 8 million naira, 8 million naira will be paid to the judgment creditor, and whatever is left, let's say maybe 1 point something million naira, will be returned to the owner of the property, because the court will not take more than it should. And the fact that the property was attached in settlement of judgment debt does not mean that the owner will lose out completely. The court is just spurring the owner to action that, okay, you don't want to fulfill our judgment, we don't do anything in vain, so we're going to spur you into action, we're going to give you impetus for action, or we're going to force your hand, but we will not take more than we owe, or we will not take more than you owe. So that is how the proceeds are distributed. That's for money judgment. Now let's talk about recovery of land. If it's a judgment for recovery of land, now the court will declare you ownership. And how do you enforce ownership? By actually entering into the land. Possession is 1/10 of the law. So and you cannot, if the judgment debtor is uncooperative or hostile or resisting the enforcement of the judgment, you cannot enforce the possession. So what you need to do is to take out a writ of possession. By that writ, the court will give you an order. The court will empower you to actually enter by force of law into the land that the court has declared as yours. So that is how to enforce a judgment for recovery of land. You take out a writ of possession. What if it's for delivery of goods? You take out a writ of delivery. What if it's for recovery of premises? That's for a landlord and tenant relationship, where they have now turned to occupier and owner of property. That is a tenant that refused to go, that held over the property, and you've taken them to court. The court has declared that they should get out of your property within a certain period of time, and they have not. You take out a warrant of possession. By that warrant of possession, the court will give you sheriffs who will follow you, and by force of law, forcefully evict that tenant. Now, you can also take out a writ of file fee if the tenant has owes arrears of rent or means profit. That is, if you have claimed it and the court has awarded it to you. So you take out a writ of file fee alongside your warrant of possession, so that as the bailiffs are throwing out the property, if it's a generator they can detain, or a refrigerator, or any movable, writ of file fee is for attachment of movable, any movable that can sufficiently satisfy the debt that they owe you in arrears of rent and means profit, the bailiff will detain it, and then it will be auctioned and it will settle your property. Because I know that many tenants feel that, I often see this, I'm a mediator, and most of my mediations are the highest. I've done a 2-year data, almost a year and 7-month data that I did. As at the last count, tenancies took a larger percentage of the mediation that I've done. And in most cases, we see tenants come and say, oh, I can live in the house, you need to give me 6 months, I won't pay. Or as you're pushing me out of the house, I'll take your rent and I'll use it to pay for another property. You are wicked. Why can't you just let me go without paying, and all of that? So if you are unable to settle amicably and you actually go to court against your tenant, you have nothing to lose as the landlord. You can take out a warrant of possession and a writ of file fee, but you have to ensure that you have asked for, the arrears of rent, the means profit, and everything when you were filing, for possession of your property in court originally. Please watch the video on tenancies for clarity on that. One more thing that I need to mention is that a remuneration of the sheriffs is also from, the sale of goods. So in the case of an auction, apart from what I've told you that the court will distribute the proceeds, the sheriffs will also be remunerated. So for out-of-pocket expenses, if maybe they took a cab to go and enforce the judgment, any expenses that they incurred while enforcing the judgment, the proceeds of the enforcement will also be used to settle them, to pay them for their out-of-pocket expenses. So if a person refuses to comply with a court judgment, apart from enforcing it, as we have spoken about, what can you do, or what should you do? I said that if a reasonable party will swiftly move into action for judgment settlement, for judgment debt settlement, that is to negotiate, a lower sum if it's a money judgment, or to negotiate, any other arrangement with the creditor. How the Bible says that before your accuser takes you to court, you should pull him aside and settle with him. So that's what you can also do in case of judgments. That's one. Two, if you don't do that, then pay up or release the property or settle the judgment, fulfill the judgment as the court has ordered it. That's two. Then if you don't do that, then your creditor can take out any of these writs against you in settlement, in enforcement of the judgment. Now, if a judgment creditor finds out that the judgment debtor is adamant and refusing to comply, we have people that maybe you want to take out a garniship proceeding against them. They have preempted you and moved all their monies out of the bank, or they have colluded with the bank to hide their actual balance, because I learned that people also do that in Nigeria. Or they've done something else to sabotage the enforcement of the judgment, because the court will do nothing in vain. Another thing that you can do is to take out judgment summons against them, especially for money judgments. You can take out judgment summons against them. That judgment summons is the means by which you compel them to come back to court. So the court will now examine them, that does this person have the means of paying this judgment sum, this judgment debt, and did they willfully and deliberately refuse to pay? So if so, the court can now make a consequential order. And some of the consequential orders would be that to send them to jail. Yeah, the court can commit them to prison until they pay up. then the court can make an order attaching their property. Then the court can compel them or command them to start to pay in installments. So the court can break it into installments for them and mandate them to pay. Yes, and then another consequential order is discharge from prison. Discharge from prison would mean that, if the court commits them to prison, that's a committal order. That's a committal. And then they are able to pay up or settle the sum while in prison. Then the court can now make an order upon application, of course, for them to be released from prison. That's discharge from prison. So those are 4 consequential orders that the court can make. But chiefly, if you take out a judgment summons, the likelihood that the court would commit the person to prison is higher. Now, another thing I want to talk about is the writ of sequestration. What's a writ of sequestration? A writ of sequestration is a writ that you can take out against someone that has been committed to prison for not paying up a judgment sum, and whose debt remains unpaid. So now you are taking out judgment summons, and the court has sent them to jail for not paying up their judgment sum, the judgment debt, and still the judgment debt remains unpaid. If it's someone that wants to pay, for instance, as soon as they go to prison, they can always liaise with their people or their family outside and order them, okay, go and pay this, go and sell this and use it to pay the judgment debt or that. But if none of that is happening, if the person is just not paying, so you can't see your money, the person is in jail, what else can you do? You can take out a writ of sequestration. In that case, the court will now will appoint commissioners. They are called commissioners, who will then go and take over the person's immovable property. We've talked about movable properties in different instances. So the court will empower its commissioners to take over the person's immovable properties. Maybe the person has, a residential building that is given to tenants for rent. So while the person is in jail, the court will take over that property and start collecting the rents, and then use the rent to settle the judgment sum. So when that is settled, the person can then be released. But the court will not leave you hanging if you can go, the whole 9 yards. So that's another thing that you can do. A writ of sequestration will make the court appoint commissioners who will take over the person's immovable property, so that they can begin to manage it and begin to harvest the profits from that property in settlement of the judgment debt. Now, that order of court does not confer title on the commissioner. No, the title only vests in them for management purposes, not for them to sell the property. Yes, and whatever they make or they get, the profit they get from the management of the property will be returned to the coffers of the court for disbursement as appropriate. It doesn't give them power to do and undo as if they were the owner of the property. That's a writ of sequestration. Now let's talk about the enforcement of judgments interstate in Nigeria. The Constitution has said that a judgment delivered by a court in Nigeria can be enforced all over the federation. So all over the federation, if a judgment is delivered in Abuja, it can be enforced in Lagos State if the rest is in Lagos, or if the person that is concerned with the enforcement is in Lagos. The judgment can be enforced in Lagos. So for the purpose of enforcement of judgment, jurisdiction can be looked at as one. But there are ways to go about it, and that's what I want to talk about now. So the registrar of the home court, that is the originating court where the judgment is coming from, will issue a writ of execution and a warrant in Form 11. You can find these things in the Sheriffs and Civil Processes Act and in the Judgment Enforcement Rules. So he will issue a writ of execution, and you issue a Form 11, that's a warrant, to his counterpart, that is the registrar in the court in the jurisdiction where the judgment is to be enforced, asking the person to actually enforce the judgment, authorizing them to enforce the judgment in their jurisdiction. So they will enforce it, and then they will make a report back in Form 12 back to the originating court's registrar, that, okay, we've enforced the judgment, this is the proceed, and this is how it went. Then they will return the proceeds to the home court as well, for disbursement as appropriate. So there are procedures to enforcement of judgment. Interstate, that is from one state to another, from one jurisdiction rather, from one judicial division. So there are procedures for enforcement of judgment from one judicial division to another in Nigeria. The registrars are in charge of this, and they know how to communicate with one another, in this regard. So what if it's from one state to another state? Section 257 of the Constitution, provides for that. Judgments can be enforced across states in the federation. There's one federation, the Federation of Nigeria. So judgment can be enforced from one state to another. The Constitution has provided for that. And there are procedures in the Sheriffs and Civil Processes Act and in the Judgment Enforcement Rules, as I've just said. If you check Section 37 and 39 of the Sheriffs and Civil Processes Act, you'll find some of these things that I've talked about. And then if you check Order 11, Rule 26 and 28 of the Judgment Enforcement Rules, you'll find some of these things as well. The provisions that I've just listed are for enforcement from one judicial division to another. What if it's from one state to another? There's procedure for that too. And there are one, you'd obtain a certificate of judgment from the court that issued the judgment. That's one. And then you would now, alongside it, you would make an application to the registrar of the court where the judgment, in the state where the judgment is to be enforced. You will make an application, supporting it with an affidavit, asking them to register that judgment in the Registrar of Nigerian Judgments. So they will register the judgment. In your affidavit, you must have stated the act that is to be done, the sum that is to be paid, what the judgment is about, what it is commanding. You state it in your affidavit, in your supporting affidavit. So the judgment will be registered. Once the judgment is registered in the Register of Nigerian Judgments, it is now deemed as if it were the judgment of the court in the state where you sent it to, where you sent your application to. And then that court can levy execution as if they were the original court. So that's how to enforce judgment from judicial division to judicial division and from state to state in Nigeria. Check, the rules of enforcement. Also check Section 257 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. So that is how to enforce judgment in Nigeria. I hope it is clear. The process for enforcement of judgment interstate, it applies to magistrate courts and high courts. Yeah, and what it does is that it gives the state courts where you have applied for the registration of the judgment authority to do everything that a court should ordinarily do to enforce or execute a judgment. So what is clear from the foregoing is that, one, the court will do nothing in vain. When the court issues or gives a judgment, it is to be carried out. And if you find out that it is not being carried out, you can take steps to ensure that it is carried out. In a way, it means that even after trial, after getting judgment, after getting victory, you cannot rest on your horse. You need to, take further steps, especially if the judgment debtor is not cooperative or not reasonable. And it also shows that, the courts in different states, Nigerian judicial divisions, work hand in hand, to enforce judgments, and they are like sister courts, when it comes to enforcement. So even if the enforcement of judgments overlaps into another judicial division or another state, it is not the end of the world. It does not mean that your judgment will not be given force of law. You just need to take the right steps as guided by the Sheriffs and Civil Processes Act and the Judgment Enforcement Rules. So on this channel, you would see that we've talked about how to institute your matter, how to conduct your trial, how to get judgment, and how to enforce it. Come on, just watch these videos one after the other. Whether you're a layman, a law student, or a lawyer, you will get a hang of it. You will get a full hang of the judicial system and the administration of justice in Nigeria. I hope that you have learned from this video, and I hope that you are so inspired that you will share it, you'd like it, you leave me comments, and you mail me at houseoflivingstones@gmail.com. That's all I have for you in this video. I will see you in my very next video. Toodles.